Millennials are having a hard time finding full-time work with the kind of salary and benefits package their parents got at the same age. Our next guest says that's the Uberization of the jobs market, and it's important for millennials to know their rights in this new kind of workplace. For perspective on this, employment lawyer at Rudner MacDonald, Natalie MacDonald, joins us now from the TSX. Good to have you with us.
Thank you for having me, Michael.
Can we explain, and I suppose essentially tell us what you mean by urban Uberization?
Well, what we're finding, Michael, is the workplace is in revolution right now, and the casualties are the millennials because they are being given temporary work, contract work, part-time work, and of course it's all at lower pay. So this obviously has a three-pronged cyclical effect on the economy. And first of all, it's bad for the economy because if these people don't have the money, they're not spending. It's bad for the socialization of the millennials because they feel that they're living in a type of welfare state. And it's also bad for their morality. They tend to be living with their parents more and more. And of course, if you're living with your parents and you're not spending money, then it's bad for the economy. Because, of course, you're not buying houses and you're not getting the loans to buy houses. So that's what's going on, and the workplace is responsible for it.
So if we're essentially seeing an increase in the freelance employee, give us a sense as to what the rights are of a freelancer versus, say, a full-time staffer.
Well, a freelancer is usually a freelancer by way of a contract, and what the myth of the contract is many employers think that if you have a contract in place for 6 months for an employee, that contract, if it says that the contract ends after 6 months, that it's going to protect the employer. The myth is that it will not, because likely that employee, if the employee works 1 day over that 6-month period, that employee may become a common law employee and therefore entitled to all the entitlements that an employee would have as a regular employee.
Oh, hang on, back up. I was always under the impression that if you had a 6-month freelance contract and they hired you on for 6 months and a day, it was essentially an extension of that existing 6-month contract. Not the case? Not
the case at all, and that's the great myth, because in the common law, they would be considered to be over the 6 months of the particular specific contract and therefore afforded reasonable notice or the severance package to which most employees are entitled.
Well, with that in mind, I can imagine it's quite a difficult decision to make as a freelancer turned common law employee to walk into that boss's office and say, you owe me.
Yes, I'm sure it is, and certainly I think, it's going to depend on the circumstances, much like everything in employment law. But certainly if the person is terminated from their contract and it's a day over, that person has legal rights and they should explore them.
How do you go about exploring them?
You have to consult with an employment lawyer, Michael. It's the only way in which to do so, because there may be a myriad of issues that you need to explore. There may be issues of not receiving overpay. There's all sorts of issues of workplace harassment these days in the workplace, human rights. So you really want to ensure that you protect your rights if you are that worker.
What of the difference between a freelance employee and a full-time staffer when it comes to benefits?
Well, a lot of companies choose not to give freelancers benefits, and it's very much dependent on the organization that you're with. If the organization has not provided benefits, there's no common law entitlement after for the benefits. But if you did have benefits under that 6-month contract, you may be entitled to continue to have them going forward if you are working a day over the contract.
What are the differences, though, in labor law when we think about it from a provincial level where it's fractured across the country versus the federal level? Here in my line of work, this is federally controlled versus most employers and employees fall under provincial jurisdiction.
That's right. So under Ontario law, we have the Ontario Employment Standards Act, and that protects employees from the basic bare minimums and affords basic rights to employees in the workplace. The federal government provides the Canada Labour Code. It does the very same thing, but it's just under a different legislation. So if you're a provincially run employee, you're going to be under the Employment Standards Act versus a federally regulated employee under Canada Labour Code.
I understand, though, it's not an apples-to-apples comparison. You go on a maternity leave at a provincially overseen industry, and you're entitled to a job back, but at the federal level, you're entitled to your job back.
Well, actually, no, that's not correct, Michael. It is actually mandatory in both Ontario and at the federal level that when you go on a maternity leave, you come back to the job you most recently had. And only if that job does not exist do you get placed in another position that's comparable. But that's a very, very serious test, and many employers can't make it.
Natalie, thank you so much for your time.
Thank you very much for having me, Michael.
Natalie MacDonald is an employment lawyer at MacDonald. She joined us from the TSX Broadcast Center. Let's look at the trade in Toronto today. The benchmark stock group is seeing investors buy